Good morning, everyone, and welcome to this Evershed Sutherland PROPcast. So our subject today is staying out of trouble, financial crime in the real estate sector. And I'm joined this morning by Steve Smith, a partner in our London office. Good morning, Steve.
Morning, Caroline. How are you?
Good morning, very well, thank you. Steve, do you want to start with a little introduction about yourself? I understand that you have both been investigator and defender in connection with financial crime.
That's right. I started off my career defending serious and organised criminals, or allegedly serious and organised criminals, and spent a number of years doing that. And then I switched side and became a prosecutor at the Financial Conduct Authority, where I prosecuted fraudsters, insider dealers, and money launderers for a number of years. And then I changed again and moved into financial crime compliance roles at various financial institutions where I worked in senior leadership roles for a number of years. And now for the last 8 years, I've been a partner here in our corporate crime and investigations team at Eversheds, where I advise regulated firms typically around money laundering issues, financial crime issues, both from a compliance perspective. I do internal investigations, and I also defend in NCA, SFO, CPS, and police investigations.
Good. So seeing all of this from all sorts of sides, very well
Absolutely.
rounded in financial crime. Okay, so my first question, and I'm going to assume, okay, that our audience, all those that are listening, are out to avoid committing financial crime rather than
Absolutely.
looking for advice on how to get away with it. Yeah. So what are the principal areas of financial crime risks that are relevant to the real estate sector?
Well, let's first define financial crime because
Hmm.
there are a number of different criminal offences that will be relevant to real estate sector, whether that's health and safety or other areas. But we're focusing on financial crime today. And what we mean by that is criminal offences that involve money or the economy where
Right.
the intention is to get a financial benefit. Sounds pretty obvious, but it's important when we're thinking about financial crime in the context of the real estate sector because it helps us think about the types of offences that we need to be thinking about that could be relevant. So I'm thinking about things like fraud, tax evasion, money laundering, theft, bribery, all offences which can achieve a financial benefit, and we know from history are relevant to the real estate sector. But when I'm thinking about the principal areas of financial crime risk, what I'm thinking about are three areas really. The first is that my company could be directly involved in committing a financial crime.
Hmm.
Second is that individuals may commit a financial crime who intend to benefit the company or that indeed implicates the company in that criminality. Or thirdly, that products and services that we offer as a company may be abused by financial criminals, principally for the purposes of money laundering. And I talk about money laundering, and I know it's very hot on the agenda, and it is really relevant right now. We'll talk about some examples in a moment about even this weekend where we've seen money laundering back on the agenda. And actually, it's estimated that £10 billion a year, £10 billion a year is laundered through the UK
Ooh,
real estate
that
market.
doesn't reflect well on us, does it
It
at all?
doesn't.
Actually, no.
And that interestingly represents about 10% of all money laundering that's estimated to be laundered in the UK annually. So property is a real go-to for professional money launderers. 10%
Oh,
of all money laundered goes through the property market. And that's no surprise really that that's reflected in the UK's National Risk Assessment last year, which found property to be a high risk of money laundering. And one of the things that I often talk with clients about, and I talk when I was in banking with my bankers about, is that it's well known that 5% of all of GDP is estimated to be the proceeds of crime. So if that is true, and I think it probably is, then we can almost guarantee that on a daily, weekly, or monthly basis, we will, irrespective of how clean and careful we are as a company, be handling the proceeds of crime. It's quite a salutary thing when you think about it that way,
but
right?
goodness, when you put it like that, for a start, the numbers are huge. If it's 5% of GDP, that so much of that is coming through the real estate industry. And I suppose you're right, just by default, just by the law of averages, we are all handling proceeds of crime at some point,
We
however
are at some
careful,
point.
perhaps. Mm,
I
okay.
think we are, yeah. And alongside these obviously prevalent risks, the heat's really being turned up by the UK government with new legislation that's been brought into the corporate crime space over the last couple of years, and a real focus on money laundering because next year in August, the Financial Action Task Force are due to come and do their risk assessment of the UK financial crime systems and controls, and we want to do well in that. So there's going to be more activity over the coming months to seek to prove how good our supervisors are and how good our enforcement space is. But in terms of the UK government, what we see both generally in the corporate crime space is steps being taken to hold corporates more accountable for the criminal conduct of individuals who are linked to those corporates. I think there's a feeling that a way that we can reduce economic crime in the UK is by holding corporates to account, to drive good culture, and to say to corporates, if your individuals misbehave, you yourselves and your shareholders ultimately will be paying penalties for that. And again, with the real estate sector being regarded as one of the money laundering capitals of the world in London, for example, we're really looking to double down on this space at the moment from a UK perspective. So obviously, for those of us who are carrying out business that is regulated, and by that I mean under the money laundering regulations, so maybe estate agents, letting agents, asset managers dealing with real estate, we do have need to have controls in place to prevent, detect, and report money laundering, terrorist financing, and dare I say proliferation financing, so we comply with the regulations. And I think it's very easy for firms that aren't regulated to think that isn't a problem for us. We're really fine. But it's actually really important that these firms still recognize that there's money laundering risk, irrespective of whether you're regulated or not. You can still be used for laundering and you can still commit offences of money laundering. There's the UK sanctions regime that needs to be complied with. Significant developments under the Economic Crime and Corporate Transparency Act, which came out in 23, which have been a real game changer in the criminal space when it comes to holding, for example, corporates accountable. You're probably aware that the press has been really bad about, prosecutors' ability to hold corporates to account for really significant and serious conduct of very senior individuals within the corporates. We see in the banking sector, for example, very senior individuals involved and being prosecuted for serious alleged frauds, but the corporate getting out at a very early stage because there was insufficient evidence to attribute the activity and the knowledge of those senior individuals to the entity. Because ultimately, a corporate is a piece of paper, right? And so how do you prove in a criminal context that that piece of paper was dishonest? Well, you take a very senior individual who you seek to prove is the directing will and mind of that entity, and then you seek to prove that as that directing will and mind of the entity, that senior individual committed a criminal offence. It's a real challenge in criminal law, which is why we've seen the SFO, for example, really struggle to get convictions against corporates. Well, ECTA has changed the rule of attribution. So it's changed the common law rules which still apply, but it's brought in statutory rules now, which is called senior managers attribution offence. And what that says now is that if a senior manager, who is somebody who plays a significant role in decision making or management within that organisation, and they're acting within the actual or apparent scope of their authority, commits a relevant economic crime offence, then the corporate has strict liability.
Strict liability.
Strict liability. So all you need to prove is that a senior manager, and the definition of senior manager is really up for grabs at the moment. It hasn't yet been litigated in the criminal courts. It will be. Us criminal defence lawyers will take a very thin view of it, saying you have to be really senior. The prosecutor and the government guidance is already taking quite a broad view of it, saying actually senior could be head of HR, for example, somebody who's head of a department. If when their role they actually commit an economic crime offence, and that is a fraud, bribery, money laundering, tax evasion, a whole heap of other economic crime offences are under the Companies Act, for example, the corporate will now have strict liability. Complete game changer from a prosecutor. If I was prosecuting now, I'd really be looking at going after the corporates. And that's been in since the 26th of December, 2023.
And this is a new approach because it's been so hard to get successful prosecutions of corporates following individual managers' actions.
It is a game changer for prosecutors. And it's something we'll talk later about steps that many of our clients are putting in place to try to put up some barriers and defense mechanisms, even though it's strict liability, to try to reduce their risk of being prosecuted in circumstances where a senior manager may commit criminal offences. In real estate, we also have the Register of Overseas Entities, right?
Yes. Mm-hmm.
Well known that overseas entities own property in the UK, and it's a real risk of money laundering, well proven. Now, increasing transparency being forced through where beneficial owners need to be registered, and if they fail to register, it isn't just the beneficial owner that may have criminal liability, but all officers of the entity can have criminal liability
Mm-hmm.
in the UK. Again, really relevant to those of us working in the real estate sector. And then the failure to prevent fraud, which I know ad nauseum, everyone has probably had heaps of updaters from law firms about, but I will talk about it very quickly. If you are a large organization, so of these three, two of them fit, you have 250 employees, a 36 million turnover, and 18 million of assets. If an associated person commits a fraud intending to benefit your organization, then you have committed an offence of failing to prevent fraud unless you can demonstrate you had reasonable prevention procedures in place. Again, it's an extension of the existing legislation we've seen around failure to prevent bribery and the failure to prevent the facilitation of tax evasion, which is where we may not, as a prosecutor, be able to have attributed senior individuals' conduct to the company. Therefore, what we'll say is that senior individuals committed an offence of bribery for your benefit. Therefore, we are going to hold you accountable for failing to prevent that bribery. Same rules apply for fraud. Again, many of our clients have been working for us in terms of what the reasonable prevention procedures comprise of. We can talk about that at the end. So
Okay.
we work.
I'm just thinking there's so many ways to be caught then, aren't there, really? I mean, even if you're not the bad actor, if you're part of a corporate, there are so many ways for your corporate to be caught. And so if we're all very, very careful about where the money involved in a transaction comes from, where it comes from, where it's sent, the source of wealth and the source of funds, which we all know we have to check. Is that enough to stay the right side of the law? Although the corporates and the people in organizations listening now, if they're very careful about the money, is that what they should be most focused on?
It's certainly a good starting point.
Right.
And irrespective of whether you're regulated or not, it's really important that we're able to demonstrate a good understanding of those firms and individuals, where they're involved in transactions, and their ability to fund the transactions that we are supporting them with, and the source of those funds. And by source of funds, there's a two-step process to that, right? Which we often forget about. The source of funds isn't just the bank account that it's come from, which it is partly. It
Yeah.
is also the economic activity that's created those funds. So we should be able to, as source of funds, be able to say that money has come from this bank and the activity that created it is X, Y, and Z. And we can be comfortable that that is a good account. And we think about real estate, and we've heard for a long time now about risks in complex ownership structures and property being owned via offshore structures where it's difficult to look through to beneficial owners, or professional advisors who are being blindly relied upon to provide source of wealth and source of funds information. And it's kind of felt a little anecdotal, I think, but it's starting to really come to manifest now in real life examples that we've seen over the last few months. I mean, even this weekend, you would have seen in the press allegations that the new Iranian supreme leader has a property empire in London worth around £50 million,
Yeah,
which
not
he
good.
shouldn't be able to afford if that's true.
Mm-hmm.
We've seen the NCA using their civil recovery powers to freeze £86 million of property in London that's allegedly linked to the Bangladeshi corruption scandal. We're seeing the asset management sector, who are arranging, fund investments in real estate, become a huge focus of the FCA, with firms being investigated and closed down, where they've actually been targeted by professional money launderers using their fund structures to invest in real estate in London. It's becoming a real issue where these kind of, and I used the word anecdotal earlier, but it's kind of, I think we can sometimes look at these things in risk assessments and think it all looks a little bit, kind of doesn't relate to me, but we're really seeing it come to play now. So it's really important that we do have that good understanding of our clients, our joint venture partners and counterparties. Otherwise, inadvertently, we can get caught up in money laundering scandals. And that doesn't just mean criminal sanctions, by the way, because what we're seeing, again, in the kind of quasi-grey criminal civil space is that where it may be difficult for the NCA, for example, to prosecute an overseas individual for money laundering in the UK, they go after property that is owned by that individual, or they believe is owned by that, and they use civil recovery powers, where they can issue an unexplained wealth order, where that individual is required to come to court to demonstrate the legitimacy of funds used to purchase a property. And if they can't do that, that property can be forfeited from them. We have property forfeiture orders, which are orders that can be attached to property, again, linked not to the underlying individual and needing to prove conduct of that individual, but applied to the property to show you need to come through and demonstrate the legitimacy of how that property was purchased. If that cannot be done, that property can be removed. It's a very low bar where we're seeing a lot of prosecuting agencies now using alternative tools available to them to start to try to break money laundering rings, etc. I mean, some might say it's an increased effort by the taxman to increase revenue for the treasury, but it's certainly meeting
There's an
success
upside.
requirements.
It's interesting. Two thoughts on that. In one that actually, as you say, it's kind of anecdotal, and everybody thinks, oh, that doesn't apply to us, and we're careful. But actually, the sheer numbers show that lots of people are being inadvertently caught up in this.
Yes,
Yeah, I like to think that nobody deliberately facilitates money laundering, but we're being caught up in it too. And then when you talk about your unexplained wealth orders or your attachment to property orders, those are huge, much stronger tools of enforcement, aren't they? Not chasing down an individual, trying to find what they own, trying to enforce a judgment against them, but literally looking at the property in front of them or looking at the person saying, prove it. Yeah, you
absolutely.
prove
Yeah,
it, otherwise we take it. So that's really quite a switch, isn't it?
it is. And what we're seeing a lot for in the AML space anyway is I think 10 years ago, the main risks for AML were criminal risks.
Hmm.
Am I money laundering here? Am I going to be prosecuted for failing to report suspicions of money laundering? Not really happening, right? But now the risks that we see for in the money laundering space are reputational, obviously. If you
Mm.
are a well-known fund and you get caught up in a money laundering scandal, it ain't great for getting new investors or
No.
explaining to your existing investors.
Hmm.
Similarly, if you're an estate agent or letting agent, it's a competitive market, and will clients come back to you if you are allegedly involved in money laundering, even if you have been innocently involved in that. And similarly, we see a lot of civil risk now, where clients who are losing out because of suspicions of money laundering are actually suing firms who are legitimately acting in the according to POCA and according to their legal obligations. And we're seeing, money laundering reporting officers sat in witness boxes in high courts having to explain issues from a civil perspective, not from a criminal perspective, but in terms of where they've caused losses to individuals as a result of their
Goodness.
activity under POCA. We're seeing that increasingly. So it's a really much broader scope to work in now rather than just being a criminal lawyer.
Okay, so I'd not heard of that before. So you might have an organization, a regulated entity, like an agent, like a law firm, like a FCA regulated body, and
Yep,
their MLRO says, oh no, we're not going to touch that. That looks, that's money laundering. And then people taking action against them for saying you stopped my deal because of your concerns.
absolutely. Yeah.
Whoa, goodness, who would be an anti-money laundering reporting officer? Yeah, somebody's got to be, I suppose.
Yeah.
Okay, so next question. Looking at what we can do to protect ourselves and the corporates in the real estate industry. So those real estate organizations, and I'm, whether owner or funder or agent or in-house lawyer, what do they have to be able to show to the regulators and investigators to prove that they have done what they should have done on both an individual and organizational level? What do you actually have to be able to put in front of an investigator or regulator and say, I tried my best?
Yeah. So that's going to depend on your regulatory status, right? So if you are regulated under the money laundering regulations, then there are clear systems and controls and steps you have to take to put in place robust controls, if you like, to prevent and deter your business from being used for the purpose of money laundering. You have a nominated officer, you have policies and procedures, risk assessment, senior managers who are made accountable. That's quite well known, right?
Hmm.
But if you're not regulated and we're sort of moving to an environment now where a lot of firms are actually becoming regulated by the back door, if you like, even though they're not formally regulated. The type of governance and procedures and controls that are required to, for example, demonstrate prevention procedures in relation to the failure to prevent fraud offence, similarly for the failure to prevent bribery, actually become almost like regulatory in types of the approach you're putting in. So
Sure.
there's 6 pillars that you'd need to be thinking about for failure to prevent fraud. You have top level commitment, which is your senior managers and your board driving the message about fraud not being acceptable for the business and taking difficult decisions where fraud is identified, assessing the risk of fraud and using that risk assessment to design and drive appropriate controls and policies and procedures across your business, carrying out good due diligence, not just about your counterparties, but about certain employees and about the business that you're in, training people, communicating messages, and then monitoring and reviewing that on an ongoing basis. And one of the interesting developments under the failure to prevent fraud offence is that it introduced reasonable prevention procedures. And I use the term reasonable, and I sort of highlight that, if you like, because under the Bribery Act, those people who are observant will see that actually the test is adequate prevention procedures.
So we've got a
And
subtle difference, adequate and reasonable.
a subtle difference, but the argument is that if something is adequate, there won't ever be a breach.
No, it'll just
So you
stop
would
it,
always
won't it,
prevent
if
it.
it's sufficiently
Yes, which
adequate?
is exactly. So reasonable has brought in a really a much more risk-based approach.
Mm-hmm.
And it's really important that firms document their approach to putting these reasonable prevention procedures in place, because in the event, and I think it's probably a likely event if you look at the prevalence of fraud, an associated person does commit a fraud intending to benefit their organization. If they can demonstrate they've got these reasonable procedures in place, they will have a defense to that failure to prevent offence, which is quite important. For the senior manager attribution offences, which again, the game changer we were talking about
Mm-hmm.
earlier, many firms are thinking about how are they actually going to mitigate risks around that? Because they'll say, well, we've got strict liability. What are we going to do? Well, we're thinking about things like training, how you drive good culture in your firm to prevent any offences occurring in the first place, your oversight, audit, and assurance. So you're picking out offences early before they become too big and prevalent. And you are looking to define roles and responsibilities so you can show whether individuals are acting within their actual authority, apparent or not. So if you're
Oh, that's
clearly
interesting.
defining what people's roles and
Mm.
responsibilities are, then if they go outside of that, you'll be arguing, well, they were acting outside of their authority, and therefore we're not going to have their conduct attributed to us.
So that's really, definitively drawn job specs for even perhaps your senior managers, so that you can say this is what they were supposed to deal with. And if they
Yeah.
went outside that, they were not acting with their appropriate authority.
And Carol, I should be clear that there's different sizes that fit different institutions and firms,
Mm.
right? Some firms will go down that route of clearly defining, and others will say, let's just mess it up and make it really hard to prove who had authority to do what. So let's have lots of
An alternative approach. Yeah.
exactly. Let's have lots of risk committees and structures where people are doing X, Y, and Z, and people in dual roles, so we can make it really hard for a prosecutor to actually unwind this and prove who had the authority to attribute their activity to us.
Well, I suppose they're both approaches, aren't they?
They are both
So there is
approaches.
a level of paperwork, isn't there, that has to be done. You have to be able to
Yes,
show your paperwork. And I always, tell the real estate lawyers here that the Solicitors Regulation Authority, if it's not written down, it didn't happen. So you've
absolutely.
got to record all your thought processes, your procedures. It's all got to be paperwork. But then it can't just be paperwork that's one and done and left to the side, because you've got to show that you are living those policies. You are implementing those procedures. It's not just written down, but actually being carried out.
So the amount of
Mm.
times I actually can count them on a hand, I think, but that I've been sat in a police station interview room with a CEO or an MLRO of large financial institutions being interviewed by the National Crime Agency in relation to financial crime offences, and the amount of times that it's come down to 1 or 2 documents that have been key documents that have either followed them through that investigation process and enabled them to stop it at an early stage,
Hmm.
or have gone all the way through to a jury, right from the beginning, maybe over a 2 or 3 year period, and there's still the same key documents for that jury that have ultimately led to their acquittal. having well documented,
Mm.
but carefully documented. And I mean by that, let's not put too much in, but well documented decisions, really, really important. It can save you later on.
Can make all the difference. Okay.
It can.
In our last 5 minutes, I've got one question on sanctions, one question on the future. So let's just briefly touch on sanctions.
Yes.
An ever-changing world of sanctions in this ever-changing geopolitical landscape. And it's very hard to keep track of sanctions lists of countries and organizations and individuals. So what are the rules there? Or is that a whole different podcast?
So I think sanctions is probably a whole topic in itself that is for another podcast. We can be here for hours talking about it, and it's kind of outside of my skill set. I really focus on money laundering because it's got so complicated now. But obviously, sanctions prohibit activity with individuals or entities that are designated for sanctions purposes. This includes not dealing with funds linked to them or making resources available for them. And in the real estate sector, again, going back to complex ownership structures and all these issues around actually identifying the true beneficial owners of entities you may be involved with, it's a real issue. And as of 14th of May, mandatory reporting obligations extended to letting agents. So nearly 2 years now, nearly a year now since last May, letting agents, irrespective of that 10,000 threshold that applies to money laundering regulatory activity,
Right.
irrespective of that, if you're letting, you are obliged to be making off-sea reports if you become aware of or suspect sanctions issues.
That's quite an amend, isn't it then? So leaving aside sanctions and their complications, what are the kind of short to mid-term future? Are there, I mean, we've got a complex and complicated landscape now, but are there also imminent changes that we should be aware of? Those working in the real estate sector, whether as lawyer or agent or funder, is there more coming that we should know about?
There is, and it's not just relevant to the real estate sector. So we spoke about the senior manager attribution for economic crime offences. Game changer for prosecutors. Yet to be used in practice, but game changer all the same. The Crime and Policing Bill, currently at the report stage in the House of Lords, is looking to extend the relevant offences from economic crime offences to all offences.
Everything, all criminal offences.
Any criminal offence. If somebody is a senior manager acting in the actual apparent scope of their role and authority, and they commit any criminal offence, then the corporate can have strict liability. And I think a big driver behind this is if we look at, the Al Fayed and Harrods issues, for example, and wanting to hold the corporate to account for conduct of senior individuals. And this is going to be a real game changer when we think about the breadth of activity that our senior managers can become involved in. I think it's going to really create challenges for corporates going forward.
That's really, I know, what a way to finish with the thought of strict liability for corporates for all crimes committed by senior managers.
Yes.
We're going to have to tag team senior managers, aren't we? They're going to have to walk around with someone from HR and compliance at all times, possibly. Maybe that's the way to go to protect us. Thank you very much, Steve. This is fascinating and frightening in equal measures. Thank you very much for your time today, and thank you to everyone who joined us.
Thank you for having me.
Goodbye.